Hello. Hi, Randall.
Oh, there we go. I'm off mute. Hello.
How
Good.
are you?
I'm doing well. How are you, Angela?
Good, thank you. I apologize for being a bit late. I was rushing from an in-person meeting that ended a little bit later than anticipated.
No worries.
Have you done the checks already?
Yes.
All right, and everything is working.
Yes, indeed.
Great. Hi, Melandri.
Hi, Angela. You.
How?
I am going to disable the waiting room in a little bit so that it's automated so we don't keep hearing the sounds as well.
Oh,
Um,
perfect. So we can't see at the moment how many people are in the waiting room.
there are 3 people currently.
All right. We had how many registrations over 70 for the event?
Yes, it stood at 81 registrations. Just
Okay.
joined.
Yeah, and we find that sometimes half show up, sometimes a third shows up, Randall. I don't know if people have webinar fatigue or if they sign up for webinars and forget, but we did send a reminder today to everyone as well.
Yes. Well, showing up 5 minutes late is on time in the webinar world too. So I
That
think
is very true. That is
I'm
very
happy
true.
to wait a few minutes beyond 11 just to get a critical mass.
Yeah. Yes, true. We can maybe start 2 or 3 minutes past or let people in 2 or 3 minutes past.
And I'm
Um,
fine with them being let in whenever they arrive. I just want to have an audience.
yes, exactly. And we will also record this, and the recording will be loaded onto our webpage and YouTube, and I will send you the recording. I'm really excited about the research that you've been doing on this. It's a very interesting topic.
Thank you. Yeah, I've really enjoyed it and was giving this lecture in various forms for many years, but this was really the first year I started to write about it, and that's been really
Okay.
exciting. We're actually hosting an event on receiving communities as a component of migration next month in our program. So really
Oh,
diving in.
wow. That's good. We've been looking for someone to address this topic at the webinar for a while, so I'm glad we have you. I
Excellent.
believe I believe you also know Amy Wilson.
Oh yes, very well.
Oh, good. Amy and I, our short course is starting next week. We have a short course on constitutional law and nature, which
Oh,
basically looks at the constitutionalization of animal rights and nature all around the world from a comparative perspective, and then aims to see, whether we can do this in the South African context. So
yeah,
that starts next week.
that's excellent. I assume you know Melanie Mercado as well.
Yes, I do. Melanie is at UCT. We're both here in the Western Cape.
Yes, I actually connected Melanie and Amy. So
Oh,
they've
really?
been collaborating quite a lot since that connection about 2 years ago.
Yes, I've seen. All right, I see people are joining. So I'm going to just give it a few more minutes and then we'll start. I'll introduce you and we'll take it from there. For those of you who have just joined, we're going to start in a few minutes. We just want to allow sufficient opportunity for everyone to join on time before we start the presentation. For those who have just joined, we're going to start in 2 minutes. Right. Good afternoon or good morning to everyone joining on the webinar today, depending on where you're joining from. It's the end of the day here in South Africa. I really appreciate for those of you who are joining, and I think it is in the morning if you're joining from the US. But welcome to our penultimate webinar for the year. Our last webinar will be in December, and we'll send those details out soon. Today we have Professor Randall Abate. He is an assistant dean for environmental law studies and a professorial lecturer at George Washington University Law School. Prior to joining George Washington in July 2022, he held a full-time law teaching position for 3 decades at 6 US law schools. From 2018 to 2022, he served as the inaugural, I don't know if I'm pronouncing this correctly, Reichnitz Family and Urban Coast Institute Endowed Chair in Marine and Environmental Law and Policy. He was also a professor in the Department of Political Science and the director for the Institute of Global Understanding at Monmouth University in New Jersey. His primary focus is on climate change law and justice, and Dean Abate has lectured and taught courses in more than 25 countries on 6 continents and has published 6 books and more than 40 law journal articles and book chapters. He is the author of Climate Change and the Voiceless, Protecting Future Generations, Wildlife and Natural Resources from Cambridge in 2019. He's the editor of What Can Animal Law Learn from Environmental Law, a 2020 book. Also, Climate Justice Case Studies in Global and Regional Governance Challenges, a book from 2016, and then Climate Change Impacts and Ocean and Coastal Law in the US and International Perspectives from Oxford University Press in 2015. He's also a co-editor of Climate Change and Indigenous Peoples, The Search for Legal Remedies. Early in his career, Professor Abate handled environmental law matters on 2 firms in Manhattan, and he holds a BA from the University of Rochester and a JD and MSL, I think that's Masters in Environmental Law and Policy from Vermont Law School. Today, Dean Abate is going to speak to us about the plight of climate refugees, rising seas, melting ice, and inadequate legal frameworks, a very significant topic given the recent ITLAW's tribunal and also the pending advisory opinion from the ICJ. Before I give over to Dean Abate, just some general housekeepings. We will have questions towards the end of the session. Prof. Abate or Dean Abate has about 35 to 40 minutes to present. And you are welcome to pose your questions in the chat or to raise your hand when questions open. But enough from me. Thank you again, Dean Abate, for joining us. It's wonderful to have you, and I'm going to hand over to you.
Thank you so much, Angela, for the invitation. It's a pleasure and honor to be here, and thanks to all who are attending today. I am going to share my slides. Go. Can you see that? Yeah. Okay. Well, this is a talk that is very near and dear to my heart. I've certainly been in the climate justice space for about 2 decades now, and the issue of climate refugees, climate migration was very much on my radar screen early on in that journey, studying and teaching and engaging on climate justice issues. And it's certainly one that is troubling to me in the sense that it has been on the radar screen of the global community for about 2 decades, and we seem to be a bit stuck in neutral about getting meaningful legal responses to this emerging crisis, global crisis, not just in terms of an environmental climate change related crisis, but a massive human rights crisis. So just to bring everyone onto the same page about where our effort to regulate climate change has precipitated this climate and human rights crisis in the context of migration. We've certainly known what we need to do to regulate climate change for a while. We have the benefit of the Intergovernmental Panel on Climate Change for decades now, issuing major scientific reports. These are not partisan politics-based findings. This is a panel of the hundreds of the best climate scientists from around the world with no political agenda, just reporting to us about what's happening with climate change. And their predictions have become more dire and urging more immediate action over the past 2 decades. And in fact, in my observation of their reports over the past few decades, the only way they've been wrong is that some of their predictions were too conservative. For instance, they initially predicted loss of Arctic sea ice by 2050, and that moved to 2030, and then we actually lost most of the Arctic sea ice by 2017. So their predictions are quite accurate. The global community knows what needs to be done, and yet there is political kind of treading water in getting that understanding of what the science requires us to do and mobilizing political and legal action on the basis of those predictions. So perhaps the best example of this treading water reality on addressing climate change governance on a global level is just a few years ago, the effort to acknowledge that fossil fuels are the leading cause of this global climate crisis. And the global community couldn't even agree on language. We're not talking about action. We're just talking about language in an agreement to say we need to phase out our use of fossil fuels. We were only able to achieve consensus on the word phase down rather than phase out. So this just gives you a sense of how, particularly in the global north, there is a failure of leadership to recognize how the fossil fuel addiction that we've had for over a century is the leading cause of this crisis, and how we immediately have to transition away from that reliance to a clean and renewable energy future. So a big part of getting that global climate change governance agreement to work is the relationship between the global north and global south. The global north has failed in its leadership role in various forms, not contributing enough in the way of funding and technological assistance to the global south to assist in that clean and renewable energy transition in the global south, so that global south countries can fully participate in this global climate challenge. And that's known as the principle of common but differentiated responsibility. And the latest version of that failure of leadership on the global North's part is the loss and damage discussions that, it's taken many years for the global North to acknowledge that it should be accountable and ultimately pay for climate change related losses and damage in the global South. And that has been moving at a snail's pace is a generous way to characterize it. And ultimately, that's another failure of leadership on the global North's part. And that really relates most directly to this emerging climate migration crisis, because we have to get ahead of this problem before we're just relocating people in the midst of yet another climate related disaster. That's not the way we want this to happen. We want the law to provide proactive mechanisms to get people out of harm's way so that they are not forcibly displaced, that they can resettle and be safe. And that's going to take a lot of money and leadership from the global North. So part of the effort to help the global South adapt to all of these climate change impacts, an enlarging part of that puzzle is the idea of climate displacement. And there are many other aspects of climate adaptation, but this idea of the climate refugee crisis is going to be a very significant piece of what it means for the global North to help the global South adapt to climate change. So climate change is known as a threat multiplier, and that is really challenging when you think about this idea of displacement. You're talking about many communities and nations around the world that are already vulnerable for a variety of reasons unrelated to climate change. And climate change over the past several decades and into the end of this century will exacerbate those existing vulnerabilities to create much larger scale crises like this climate displacement crisis. So one of the reasons why we're seeing a failure of leadership and action in this space is that the issue of climate refugees really sits at the intersection of two major global governance fields: international environmental law, particularly global climate change governance, and international human rights law. And just like the phenomenon when you send one email to two people and don't receive a response from either one of them, this is really what's happening with the effort to find leadership on the climate refugee crisis. International environmental law doesn't feel like it owns this issue because of its human rights dimensions. It's not squarely an environmental governance issue. And likewise, the international human rights community has devoted much more focus to traditional human rights challenges that aren't intersecting with environmental aspects like climate change. So prohibition against genocide, protecting indigenous peoples' rights, protecting women's and children's rights, and so forth. So there is and needs to be much more climate refugee crisis communication to get these two fields to work together more effectively, to raise the awareness of climate displacement as the pressing crisis that it is, and to acknowledge that it's the quintessential kind of intersection of these two fields that requires full engagement from both. So this crisis is emerging so fast that there was a number that I used when I started giving this version of this talk, maybe 7 or 8 years ago. Well, even prior to that, there was a lower number, but in 2021, the World Bank came up with a number of 200 million people worldwide would be displaced by climate-related factors, climate change-related factors. And that was already a daunting figure. 200 million then was at that time 20 times greater than the entire number of refugees for all other reasons worldwide under the jurisdiction of the UN Refugee Agency. And just 2 years later, another estimate was put forth on this issue, and we're looking at now 1.2 billion, significantly larger than 200 million as a projected figure by 2050. We're not even talking about the end of the century. We're talking very much on the near horizon. And when you think about that number of people, and it's likely a conservative estimate, given how fast this crisis is evolving. There has to be a very effective, very proactive legal framework to address a problem on that scale. And currently, we basically have nothing under international law that is mandating some kind of effort to protect and resettle climate displaced peoples. So there's a lot of layers to this problem. And so the first challenge is terminology. I'm using the term climate refugees just sort of as a placeholder, but it's important, and I will explain that there are a variety of terms in the field that refer to those who are displaced by climate change. Climate refugees is one of those. It's starting to fall out of favor, and I'll explain why. And we'll talk about some of the other labels that are being used. And so the terminology about what we mean by climate refugee or whatever the label is, and what sort of instances would this class of people be protected from under the law is another scope challenge that we face initially. And then I'll just give you some case studies about how this is manifested in the US and at the international level, and how it's growing quite quickly without an adequate legal response in place. And I always try to end climate-related discussions on a hopeful note, which gets harder and harder each year. But there are some ways of thinking about this issue where we're seeing progress, more so at the regional and domestic and sub-federal levels in countries around the world that are aware that something needs to be done, even without leadership from global governance of the problem. There needs to be engagement of existing legal mechanisms to respond to this problem to the extent possible. So we'll discuss some of those. So just in terms of getting a working definition, if we're using the term climate refugee, we start with this premise of vulnerability. And the good news is that most people worldwide are not necessarily in vulnerable situations now, but that is changing very quickly in the global north and south. I mean, certainly the global south is more vulnerable than the global north to these threats, but we're just seeing rapid changes in what it means to be vulnerable based upon how quickly climate change impacts are manifesting. If you just consider the US, I mean, wildfires weren't even an environmental threat on my radar 10 years ago. Of course, I always knew about hurricanes and the threat they pose, but prior to Hurricane Katrina, it wasn't this regular annual devastating threat in particularly concentrated areas of the US that are becoming, with each passing year, less and less habitable. That was not part of my reality, certainly when I started law school, or even more than 20 years ago. This is a very recent reality that the law is trying to respond to, but of course, in a very reactive way, it needs to be proactive. So the idea is that you are either already displaced, and hopefully that isn't the case, because it's much harder for the law to respond effectively if you're already displaced. The goal is, if you are in imminent danger of being displaced, and imminence can mean next month or 3 or 5 years from now, the law has an opportunity to protect you from that impending harm, and that's really the best approach for the law to respond to this kind of challenge of climate displacement. And the reality here that makes the term refugee perhaps not the best term is that you're not just displaced or in imminent danger of being displaced from where you call home because of climate-related threats, but you're unable to return to what you called home. And that's fundamentally different from the way international human rights law currently defines what a refugee is. And we'll talk about that a bit later. So there are other terms out there in the literature. Climate displaced peoples, I've mentioned as one of them. Climate migrants is another, and I have concern about that term because migrant to me implies volition, and in most instances, these are not voluntary relocations. These are forced displacements because of climate-related impacts, whether we're talking about hurricanes or wildfires or food and water insecurity. These are forcibly displaced communities the vast majority of the time. There's not an element of choice. So there are two dimensions of this that create a scope issue, and one is the reality that a lot of this displacement we're seeing around the world, global north and global south alike, is internal displacement, meaning that it's happening within an existing country. And we've seen a lot of that already in the US, and it's happening around the world. And so I'll give you a case study on the domestic and international sides of displacement related to climate change. But then we also have the dimension, as we saw with Hurricane Katrina and other major hurricane-related disasters, is that sometimes displacement is temporary, that it's just a major event that requires evacuation for a certain period of time, but ultimately the communities are able to return to what they called home after a period of time. And the question would be, does the legal framework, whatever it might be for climate displacement, also protect those temporarily displaced, or does it require some kind of permanent displacement, either internal, domestically, or transboundary across national borders? So certainly from an international governance perspective, the transboundary displacement is a big issue that only the international governance regime can adequately address. So those who are most vulnerable really have a daunting challenge because they lack the political and economic power to force the global governance community to do something as urgently as they'd like. And so this has been around for a while, and this was going back to 2003, 2 decades ago, when this was already emerging on the radar screens of Pacific Island nations, knowing that they were doomed, and it was really just a matter of when they would have to move due to sea level rise from the island nations they called home. And so an effort to be provocative about communication about that threat was already engaged, and the Prime Minister of Tuvalu, making reference to the global North's failure to adequately regulate climate change the way they're capable of and ought to, was essentially amounted to an insidious form of terrorism against the Pacific Island nations, who were just bracing for impact and relying so heavily on the global North to take the leadership role that it can and should play. So this is a very popular case study from the US. This is a community of 400 Native Alaskans way up at the top of Alaska in the North Slope, at the top of the state where it starts to slope down, a coastal area in that region, and a very narrow strip of land that wasn't always this narrow. So this is a function of sea level rise, coastal erosion in this area that has made this area that this community of Native Alaskans has called home for about a century is essentially going to be uninhabitable. A study was conducted by a government agency, the U.S. Army Corps of Engineers, about 20 years ago, concluded that these Native Alaskans had about 2 decades to stay here before they would essentially be underwater. And so this is not a current photo. The current photo is a bit more dire, but ultimately the shocking reality is that this is now a crisis that's been going on for 2 decades, and no legal response has come. And what's perhaps most embarrassing for the legal community, both domestically and internationally, is that this community and several other Native American communities around the country who also were not assisted in the context of an imminent need to relocate because of climate change impacts and no support and funding for that. These communities banded together and just over a year ago filed a petition before the Inter-American Human Rights Commission here in Washington, D.C., against the United States, seeking to draw awareness to the fact that the U.S. failed and ought to provide funding and technological assistance to help all of these communities relocate to a place where they will be safe. And in this case, a lawsuit was brought way back in 2006 or 7 by this community, the native village of Kivalina in Alaska. They sued about 24 of the leading oil and gas companies, multinational companies, who collectively contribute to a significant portion of global carbon emissions. And they sued them on the theory that because they were such significant contributors, such a small group and such a large contribution to the global phenomenon of climate change, that global phenomenon of climate change contributed significantly to the sea level rise in northern Alaska and to the peril that this community faced. They were seeking the recovery of the money it would take to relocate this tiny community. You might not think that would be much, just relocate 400 people 10 miles inland so that they wouldn't be in the water in the future. And that turned out to be a price tag that the federal agency that conducted that assessment to be $400 million to relocate those 400 Native Alaskans. And that was the money they were seeking from those fossil fuel companies to help them relocate from this place of danger. And that lawsuit lost. Not surprisingly, it was an ambitious strategic climate litigation effort, and many of them do lose on the grounds of causation under standing, just being able to get into court to make your claim. This has nothing to do about winning your case. Even at that level of the litigation, causation is a relatively easy standard to meet. The U.S. law just requires that it be fairly traceable. The action or inaction of these defendants is fairly traceable to the harm, the injury that these plaintiffs are experiencing. But the court here said this case failed on the causation grounds, primarily because back then it was true, science could not connect the actual emissions from those companies to that sea level rise in northern Alaska. It was impossible to make that connection. But now, 20 years later, we have a rapidly evolving field of climate attribution science that is helping connect specific actors and specific climate impacts, which is encouraging for this kind of strategic litigation and for better protection of vulnerable communities who are experiencing these threats. So there was a standing barrier. There was a political question doctrine concern. This is a jurisdictional concern where the court says, you're not bringing your concern to the right place. This is a global issue. Climate change should be handled by the executive branch. And it's also an issue that should be handled legislatively by Congress, that we have the Federal Clean Air Act. And if you want climate change related relief, you should seek relief under our existing Federal Clean Air Act. So we're going to dismiss this on jurisdictional grounds as well, because the courts are not the right place for you to air your dispute here. And then that doesn't speak to the fact that causation is a much higher standard if and when these cases get to trial, and it's very hard to get to trial for these reasons. But one thing I want to focus on about the obstacles to recovery here for climate displaced peoples is the agency that's there to rescue those who are vulnerable in the U.S. is the Federal Emergency Management Agency, FEMA. And you hear a lot about them with respect to hurricane response, and they've been the subject of criticism in many contexts in terms of the speed and adequacy of their responses. But what's most important to think about in terms of climate displacement is FEMA's charge, if you will, as an agency, does not authorize them to intervene before a disaster occurs. So this is very, very limiting and ultimately is a problem for vulnerable communities. They are literally standing in harm's way, and FEMA is not authorized to help them until essentially they're in the water. In the context of the Kivalina community, they're not able to act before the disaster strikes, which makes no sense. And we know, based on the science I referenced earlier in the presentation, we are very aware that it's only a matter of when and not if these vulnerable communities will sustain climate-related disasters and displacement. And it's just cruelly ironic that the federal government is not authorized through its Federal Emergency Management Agency to get people out of harm's way before those disasters strike. So that is an effort underway, and some of the writing that I've been doing and other scholars about adjusting the mandate of FEMA to intervene before disaster strikes. So there have been other case studies, many, in Alaska and around the country, indigenous communities and non-indigenous communities that are vulnerable to the threat of climate displacement. And we've seen virtually no response from the federal government. A very limited success story, if you can call it that, was that there was a grant program where communities had to compete for money, which is ridiculous if you're in danger of being displaced and you need to find a new place to call home. You shouldn't have to compete for funding to get help. But one indigenous community did compete and secure funding. And again, look at the price tag, about $1 million per person, like we saw in Kivalina, to relocate 60 people, $48 million. And the postscript on that story is that that relocation did not go well. So even though the money was secured, there was a major concern about the adequacy of that resettlement process. And a fair amount has been written about that in the Ile de Jean Charles in Louisiana. So one thing that we owe a debt of gratitude for, those of us who are seeking to enlarge the response on climate change and human rights, climate justice, climate refugee responses. A lot of this wouldn't have even been on the radar screen of many had it not been for this groundbreaking petition that another indigenous community, this time the Inuit, that exist across the Arctic region in the US, Canada, Russia, Greenland. And they filed, again, a petition to the Inter-American Human Rights Commission, again, against the US, and alleging this time that the accelerating loss of ice in the Arctic was in part due to the US's failure to, at that time, be a party to the Kyoto Protocol, the global agreement to regulate climate change. And so what was really significant about this case was not the outcome. It was literally a 2-paragraph decision that the commission ultimately issued, saying there's no basis in international human rights law on which we can, offer any kind of relief. Refer this to the court for you to secure relief under international human rights law. But the way the petition was fashioned, using international rights law protections, connecting them to their climate change related loss that they were experiencing with the melting ice, was groundbreaking in the sense that it really laid a foundation for this field of climate change and human rights to emerge. And we've seen tremendous success globally now in strategic litigation on that theory. And certainly post-Paris Agreement, a lot more, with a platform in the Paris Agreement, in the preamble of all places, not even binding language, but acknowledging the connection between climate change and human rights. A lot of that wouldn't have been possible without this unsuccessful petition that was brought by the Inuit. So the way they fashioned this connection between climate change and human rights was very compelling. How the melting they were experiencing all around them was connected to an infringement of many human rights that just happens to be connected to an environmental reality, the melting ice caused by global warming. And so ultimately, all of these human rights were collectively referred to as a right to be cold by the leader of the Inuit community, Shilawa Cloutier. She actually wrote a book by that title, The Right to be Cold. I recommend that. And you can see that it goes to all these ways in which the Inuit community defines itself. When you're talking about a loss of ice, it's their very existence, their very culture, their very identity that is bound up in that ice that is rapidly melting around them. So that certainly was a valuable step, losing the battle, winning the war, so to speak, in that petition. And of course, I went through some examples of how winning these kinds of cases are very difficult under US law. They're even more difficult under international law. International litigation is certainly going on with respect to climate related harms, and to some degree very limited about displacement issues. But the real challenge here is just the jurisdictional realities of bringing cases under international law. You don't have that enforcement capacity. You don't have that a party that doesn't comply with an order is subject to the contempt powers of the court like we do in the US. This doesn't happen at the international level. So it's much more difficult to have effective litigation that creates concrete outcomes that are positive for those vulnerable communities. But as Angela noted at the beginning of the hour, we are seeing encouraging efforts seeking advisory opinions related to climate change and what nations are expected to do to protect against the impacts from climate change. Many of these are related to human rights concerns caused by climate change, and that's a positive step. Today's soft law, if you will, non-binding law, is going to be tomorrow's hard law. So these are valuable steps in these advisory opinions that are addressing this challenge of trying to mobilize the global community to do something about addressing climate displacement, albeit very slowly. So this is an example here on this slide about how the term climate refugee is a misnomer in the sense that our understanding of what a refugee is really doesn't line up with what's happening with climate displacement. That red highlighted language doesn't apply to climate displacement. So traditional refugees are on the basis of a fear of persecution on a variety of bases, one or more of these: race, religion, nationality, political opinion. You are making a decision to leave where you call home, and because of that fear of not feeling welcome, you are choosing not to return to that place you used to call home. So that's not at all what's happening with climate change. It's a forcible displacement because of climate-related factors and an inability to return to what was home because of those environmental factors. So that's where the idea of climate refugee is called into question. A counter argument would be that, but we understand that notion of what refugee means. It's an existing point of reference, and it's somewhat provocative. Climate displaced peoples sound sort of bland. This is an urgent crisis that requires global attention and action. So that label refugee has that value of being familiar and provocative, very much like that reference by Tuvalu's prime minister about calling the global North's inaction on climate change a form of terrorism. You need to use terms that get attention and mobilize political will and action. So another major challenge about the climate displacement concern on a transboundary level is statelessness. So there's a recognized definition of what elements need to be satisfied to be considered a state under international law. And these four elements, that territory element is a huge problem potentially for a very significant number of states, roughly 200 states recognized as countries under the UN, and perhaps 50 of those might be over the course of the next century in danger of losing statehood for loss of territory. Pacific Island nations, Caribbean island nations, and vulnerable nations around the world. Bangladesh is one of the most vulnerable places to sea level rise in the world. The Maldives. So it's very much a focus on that South Pacific region, but many other countries would be in danger of losing their statehood because of climate-related factors that would force them to have to live somewhere else. And that effort of relocating would essentially mean, do you have to nationalize into citizenship of another country? Can you somehow retain your sovereign identity when your territory is no longer there? So that's an ongoing discussion, and not one, like much of what we've already heard, that's happening fast enough. So then we've got this regional reality, and I can share an article in the chat that I wrote about this year about the U.S. and India. They're both what I would call, and my co-author Chaya Bardwaj would call destination countries. The idea that in the East and West, there are countries that are going to be more likely to have many people from many other countries in that region flooding into those destination countries as a place of temporary, if not permanent, climate havens, because they are no longer able to live where they currently live in their countries. So in India, that's a particular concern because India is already extremely vulnerable to climate change and is experiencing a massive amount of internal displacement because of climate change. 5 million climate-related disaster displacement events in 2019. That was the highest in the world. So India's internal displacement is in record numbers, and yet it is also de facto a destination country for the South Asian region in terms of where's everyone else going to go. It's less vulnerable than the countries that surround it and has a more stable economy. So that's certainly a crisis that is unfolding, and the goal of our article was to look at both the US and India and existing legal mechanisms that might be able to facilitate that receiving of displaced peoples from outside the countries. So the challenge here ultimately is there's not going to be an easy solution, especially when your solution slide has more questions than answers. You can see that readily. We aren't going to have a ready-made response with global diplomacy in terms of a protocol to the existing Paris Agreement or a new climate change, refugee, or displacement treaty. That would take more than a decade, as most treaties do, and would not be the relief that vulnerable nations need soon enough. So it is likely going to be related to funding as a response that has to happen sooner than later. It's likely going to be a regional response, something that has to happen on a region by region basis. Different crises in different regions will require different responses. And then all of these challenges that we've discussed have to be overcome in the process of getting a meaningful response. And there are a lot of ways in which existing law can respond to some of these questions. And one of those is in the US, we have a strong system of immigration and asylum law that can be adapted with a climate sort of displacement face, if you will. The notion of a climate visa rather than just a traditional visa where there's some temporary opportunity to find a safe place while the law and logistics figure out what's next. So we have to be as creative and quick as we can to address all of these problems. And so ultimately, I will skip to the questions. I'm very eager to hear your questions and comments, and thank you so much for your attention.
Thank you so much for that insightful presentation. I have quite a few questions, but perhaps let's see if the audience has any questions before I ask mine. I don't see any questions in the chat, but to the audience, you are welcome to raise your hand if someone here has a question. All right, perhaps maybe I'll invite the audience to think of a question and I'll break the ice. So my students and I actually had a session on this a week ago, and some of the things that we were discussing, and perhaps you can say which of these you want to address. I'll just tell you 3 things we discussed in class. One was the potential of the principle of non-refoulement and trying to perhaps reframe that in the context of climate displaced persons. And then the other was questions about climate displaced communities and statelessness, and whether and if we do so, how can we do so? But should such communities be allowed to claim sort of a safe haven? against the international community of states at large, or against those that disproportionately are responsible for sea level rise. Questions. So this was based off of a reading we did by Skillington, who suggests a corrective justice approach. Not sure if you're familiar with the paper, but they write about climate dislocation and assigning responsibility for displaced communities to states in proportion to their wrongdoing, particularly with emissions or historical emissions, sorry. These are just the debates my students and I were having, and I was wondering what your thoughts might be on this.
Yeah, those are excellent questions, and very much in the scholarly discussion on this issue. I would say that on the non-refoulement piece, there have been courts that have considered that question. It's very early in that process, and I would say that there's some kind of hope that this could evolve in terms of, in principle anyway, this idea that climate displaced peoples ultimately have to be protected when they are forcibly moved somewhere else and are not just simply going to be sent back from where they came if that is no longer a habitable place. Some courts are recognizing that as connected to human rights based protections. And so a recent case in India that's in our article did address that. Not conclusively, but certainly is part of an emerging discussion about trying to connect human rights to this idea of when you are vulnerable or have already been displaced, that a certain set of human rights protections are triggered, and ultimately that will make this sort of move forward in a way that is hopefully less like social Darwinism, that you are just a leaf swaying in the breeze, that the law just doesn't have any foundation to protect against that vulnerability in response to your displacement. So I think on the statelessness issue, interestingly, one of my students is writing a paper this semester in my international environmental law course as one of many theories out there regarding how to maintain statehood in the face of loss of territory. And it's actually something that is quite science fiction, if you will, about creating a digital twin of your sovereignty in cyberspace, and essentially not requiring that there be physical territory, that second element of the four, that would have to be met. Because if we do stand rigid and inflexible on this notion of physical territory, it's going to be very difficult for the global community to maintain recognition of these states that will lose their territory. So we have technological solutions to many other problems, and that might be one way of maintaining sovereignty. And we have other examples in history where circumstances allowed this idea of sovereignty to persist in unusual circumstances. We have the Holy See as recognized as a sovereign entity. We have the government in exile concept that has appeared in history. So we just need to remember that flexibility is something that is going to be more important than ever in thinking about climate adaptation to displacement. And another one of my colleagues who's been active in this space in the US, Maxine Burkett at University of Hawaii Law School, she wrote an article about 10 years ago called the Nation Ex Situ, which essentially was advocating for a nation like Tuvalu, for instance, to maintain its sovereignty when it relocates to another nation, just somehow be located in that nation, but maintain its statehood as a guest of that nation, if you will, without requiring nationalization of those displaced people from that displaced nation. And then you've got some sort of ad hoc responses that we're seeing with Kiribati, for instance, where they are in the process of creating an artificial island where, when their existing territory does go underwater from sea level rise, they are planning to relocate to a new place that can fulfill that territory requirement if we're going to have a narrow reading of what territory means. So those are just a few thoughts.
Thank you. I find the concept of a digital twin quite interesting. I was recently doing some research on urban climate resilience to potentially update a book I wrote or edited 2 years ago. And I see that city authorities are using that technology to plan for, their climate adaptation and mitigation measures. So it would be interesting to see how that, we'd have to reconceptualize the way we conceive of sovereignty, of course. And those, I think it was 4 requirements for a state to be a sovereign state. But it would be interesting to see where that goes. I think certainly AI and technology and law is moving in directions like that. I think people are even trading in virtual property. So this might be a solution.
Yes, yes, and I'll be happy to share that student's paper. I'm certain it's going to be published. So once it's in shareable form, I'll be happy to follow up with that.
Please do. Thank you. All right. Is there
Hi,
perhaps a
Prof.
question? Oh, there is a question.
Yes,
Yes, who
Prof.
spoke?
Yes. It's Wendy here.
Oh, hi, Wendy. Yes, you're welcome to ask your
Hi.
question. Thank you.
I wanted to ask Prof. Abate, is there any way that we can actually link climate change to criminal law, maybe the criminalization of the communities that I don't know, maybe the communities that I don't know how to really put it, but the communities that are found in maybe in contravention with all the laws and the regulations of climate change?
Yes, I
How
think
do
that,
we deal with that with the criminal law aspect?
yes, that's certainly something that is being discussed both at the global level and in the U.S. on a domestic level. So the term under international law that's being proposed for this is called ecocide, um, like genocide. So essentially, trying to make an argument that it is criminally irresponsible to continue to contribute to a global phenomenon like climate change with disregard for the consequences. I mean, there's certainly been a lot of activity, both with the idea of the loss and damage mechanism, that there should be some sort of traditional civil liability, meaning that you have an obligation to pay damages when you cause harm. But because of the level of awareness of consequences and because of the extreme nature of those consequences, that there has been a lot more discussion of late about criminalizing that failure to respond appropriately, and that's really where the Prime Minister of Tuvalu was coming from. This idea of the failure to act when you have the capacity and know you should, and yet you choose not to because it's inconvenient. I mean, that is essentially a form of terrorism, and that would be criminally responsibility to attach to that kind of action or inaction. So at the domestic level, I actually have a colleague at GW Law who just published a very well-received article about the idea of criminalizing the fossil fuel industry's awareness of the consequences of its activities on climate change and proceeding in disregard of that reality, engaging in disinformation campaigns to deceive the public about the severity of the problem, and holding them criminally responsible for that behavior. There are cases that are talking about civil responsibility, which would be a great first step, but that article actually advocates for mechanisms under U.S. criminal law to hold these multinational corporations responsible for their failure to act appropriately.
Thank you, Prof. That is noted.
Thank you very much. We have time for a quick final question, if anyone has a final question for Dean Abate.
Hi, Angela.
Yes,
Just
Dr.
a quick
Stenkamp.
question from my end. I'm wondering, Prof. Abate, you mentioned about the finance issue. So I am thinking of how can climate adaptation finance, especially, be used to scale up or just better address the threats or needs that communities at risk of displacement can face. So how would, climate funding such as, the Green Climate Fund, etc. So how can that be used? And are avenues of green or at least adaptation finance being explored currently?
Yeah, that's a very good question. I think the bad news is that, we already had a broken system in terms of climate finance before this emerging need for funding for climate relocation. So we have the Green Climate Fund, and there was an expectation that that would be generating $100 billion per year from the global north to help the global south adapt to climate change impacts of many varieties. And not surprisingly, the global north did not live up to their responsibilities in meeting that. Certainly, the U.S. being chief among those that fell far short. Just to give you an example of the scale, I mean, it sounds like a lot of money, but the U.S. is expected to give $10 billion per year into this fund, and that sounds like a lot of money, but the response to Hurricane Katrina alone, one major hurricane event in the U.S., was 30 to 40 billion dollars. So when you think about the debt that the U.S. owes to the global South in terms of being so largely responsible, a leader in the responsibility for the global climate crisis, giving 10 billion to the entire global South each year is a drop in the bucket. And even under the Biden administration, there was balking. Certainly don't expect a penny if Trump gets reelected. So when we think about trying to transition to funding climate relocation, if we're already experiencing a failure in funding climate adaptation from the global north to the global south, it's going to be difficult to do that on a global scale the way we ought to and would be useful. So I suspect a lot of that will be happening on a more regional and national level. It has to happen somewhere.
Thank you very much. We are officially at the end of our hour, but thank you, Dean Abate, for that very insightful presentation and for answering our questions. There is so much more we can say about this topic. I think we're all also waiting in bated breath just for the advisory opinions from the ICJ and even the Inter-American Court. I think they also had questions about refugees and disappearing states. So it's definitely a space to watch, and I'm sure your research on this will progress, and hopefully we can invite you back. But thank you very much. Thank you also to everyone who attended. I see your articles. I'm going to download them. There we go.
Yes, two
And
of them are actually mine. The U.S. India one and the one I just shared, those are articles that I co-authored. And then the climate homicide is the article by my colleague, Don Brayman.
excellent.
And I saw in the chat about sharing my slides. I'm happy to send those to you so you can share.
Thank you. I appreciate that very much. All right. And then this recording will also be made available on our YouTube channel, which I will also then share with participants and with you. But thank you again, and thank you everyone else for joining, and keep an eye out for our final webinar of the year, which will take place in December, likely in the first week. Thank you, everyone. Have a lovely evening and have a lovely morning to those of you in the US.
Thank you all.